Well, good afternoon and welcome to our December Ranching One webinar presented by AgTrust. Today you will hear from an industry expert and learn what to keep in mind when planning for the next generation. Before we start, please join me for a short message from AgTrust.
When your passion is agriculture and a rural way of life, you need a partner who understands. That partner is AgTrust Farm Credit, formed from two trusted farm credit associations. Our mission is to provide personalized financing tailored for full and part-time farmers, ranchers, agribusinesses. Farm Credit is here to help you succeed.
Well, at this time, I'd like to introduce our guest speaker. Garrett Couch specializes in estate planning, probate, real estate, energy, business formations, transactions, and agricultural law. He studied agricultural communications with a minor in agribusiness and political science at Texas Tech University and earned his law degree from Texas Tech School of Law. Garrett worked for Congressman Mike Conaway on the 2013 FARRM bill and gained legal experience at firms such as Saylor Law, McCleskey, Harriger, Brazil, and Grafe and McWhorton, Cobb, and Johnson. After law school, he practiced extensively in probate, energy law, real estate, and litigation before joining Brady and Hamilton in 2019. If you have any questions during the webinar, please submit them in the chat box. And at this time, I'd like to turn it over to Garrett.
Thank you very much. I appreciate that. That intro makes me sound much more important than I am. You can dilute about half of what she kindly said there. I'm very excited to be back here today. Always happy to do anything with the great folks at TSCRA. We'll talk about this a little bit, but I grew up in the Panhandle up in Pampa. That's big TSCRA, country. Everyone we know was TSCRA members, so I'm excited to be getting involved with it now in my career. I'll give you a little disclaimer. I got diagnosed with RSV yesterday, so I'm a little winded. So if I have to take a little breath here and there, please forgive me, and I'll try to speak up regardless. But if you're having trouble, just send in the chat or something, and TSCRA will flag me that they can't hear me or something like that. They'll put up a big nasty sign and get my attention. So I'm going to share my screen really quick so that we can get started. Okay, so in theory, you should have my slides. If you don't, I'm sorry. So we're here today to talk about, in general, planning for the next generation. So in one way or another, that can involve a whole lot of different things. And my intent here is probably to take up the whole hour, but I'm happy to stay after that to answer questions if you have them. You'll see on this slide, whenever I give a presentation about what I call ag transition planning, aka planning for the next generation, transitioning the ag operations to the next generation, there's a whole lot of things we talk about, and I typically drop them into these kind of like 8 buckets, right? Intro, not really counting, so I guess 7 buckets. But you'll see I've marked basically everything on the left out for today, basically for time purposes. It's really going to take an hour to do 6, 7, and 8. So I've eliminated 2 through 5 because we didn't really have time to do them. But everything on the left is kind of planning for life, the remainder of the operations under your control before they really transition to the next generation or as part of the transition to the next generation. 6, 7, and 8 tend to be the things we think about as the end of the road kind of planning, right? So we're really going to focus on those. And as you can see, it looks like a pretty full schedule. That's me. Ignore that. We photoshopped the heck out of that photo. I'm a partner at Brady and Hamilton. Our main offices are in Lubbock and Austin, but we service all of the state of Texas and the state of New Mexico as well. And so we are happy to be here. I'm in the Lubbock office most of the time, make it down to Austin several times a year as well. So we're proud to be representing all Texans across the whole state. So like I said, I grew up on Couch Farms way up in Pampa, Texas, way up there in Texas, Canada, way at the top. We get real winter, actual snow, very common to get actual white Christmas. Fingers crossed this year for some of that moisture. We'll see. As you can see, we got all kinds of stuff. So as I said, everything on the left are really going to kind of ignore for today. Everything on the right, we're going to focus on as the main topics. So there's a lot we're going through. So you might want to buckle up. We're going to move pretty quick. I'll try to enunciate. I'm getting in trouble for talking a little too fast. One of my AgCom faux pas that I probably need to get over, but it helps us cover some ground. So disclaimer I got to have, yes, I'm a lawyer. Yes, I'm talking about the law. That doesn't mean I'm giving you legal advice specifically for you. I'm not necessarily your lawyer. So nobody message in the chat where the bodies are buried. We'll have to tell the police. But if you want to make an appointment and tell me later, that's fine. Fair use. I stole all the images in this presentation except for the Couch Farms hat you just saw and a picture of my dog that I think is stuck in here somewhere. Basically, everything else are other people's creations, but this is a not-for-profit activity by me, so I posted my fair use disclaimer. Now, we're not possibly going to be able to cover every aspect of transition or estate planning in an hour, right? So this is really the tip of the iceberg, but the point of this is for you to maybe drop some mental flags or roadmaps so that when you're addressing this with your plans or your family, you can think, oh, that lawyer might have mentioned something about that once. Maybe we should talk to a lawyer, or maybe we should look that up, right? That's really the point here, is to give you the high points, let you drop some pointers along the road, maybe some breadcrumbs down the trail to pick up later when you go to address this for yourself. So when I keep saying the word transition planning, that's probably not something you come across all the time. Most people hear estate planning or a will, right? But they don't hear transition planning. So why do we call it that? Transition planning really has a lot of different definitions. It depends who you're talking to. But for ag, it's essentially planning for the use of your assets and the operations for the next generation, but during and after your life. So most of the time when you're talking about estate planning, you're talking about once you're dead. But we don't want to just move your assets all at once to your heirs, right? You're still here, you're still kicking, and you still need to operate the farm. And so transition planning is, how do you continue to utilize those assets now for the uses you have them for currently during the remainder of your life, but prepare them or start transitioning them to the next generation now. That's why it's a little bit different than estate planning. So the number one thing to know is this is a team sport. This tends to catch a lot of people off guard because like, oh, I'll call my CPA and he'll do it, or I'll call my lawyer and he'll do it. But really, when we're talking about a full comprehensive estate or transition plan, it's a real team sport, right? You're likely going to have a lawyer, a CPA, probably your FSA or USDA local person that you talk to at your local county office, any other business partners that might be involved in the farm, whether that's your family members or non-family members, whatever that may be. And then your heirs, right? Your actual family may or may not be involved in this in one way or another. Now, one little caveat, because us lawyers love caveats, even though it's a team sport, there are parts of it that have to be individual. So it's really common, especially in ag, and this is a good thing, that parents come in, want an estate plan, and they want the kids involved in every step as well. Nothing wrong with that. But there are some legal hoops we have to jump through, because technically you want my information provided to you to be private, right? The whole attorney-client privilege thing. That goes away if all your kids are sitting in on the meeting, usually, right? So there's some things we need to do to make that work. So I'm not telling you don't involve your kids. I think it's great if you do. But there might be some points throughout the process where I say, hey, we really need to step out and just talk just us, right? Or I need to hear this straight from you in private, right, to preserve some of this attorney-client magic behind the curtain, right? Now, I lied to you already just a little bit. Stereotypical lawyer again. I said we weren't going to cover business entities. It was on the left, but I can't in good conscience skip it completely. So we're going to touch it real brief. And the reason for that is the way in which you organize your farm operations now, whether they're individually held by you or in an LLC or a corporation or a partnership or a limited partnership, whatever it is, that can have significant impacts on your estate planning later. So I want to cover it real quick. This is a horrifically ugly, don't tell any of my AgCom roots people, little info sheet I used to give clients way back in the day when they first were talking about establishing an entity. Now, here is a very brief summary of the entity options you have in Texas. So you have your, sole proprietorships. If you own it outright in your individual name, it's a sole proprietorship. Partnerships, LLCs, corporations. And then, of course, there's subsets of all those, like limited partnerships or limited liability partnerships or closely held corporations, right? Or series LLCs, right? There's all these different shoot-offs, but those are the main buckets. And which of those best fits your operations will depend highly on several different things. This is an entire area of my practice is just business entities, right? Separate and apart from all my other ones, because you can spend, I could probably fill my whole billable year just doing this with clients, trying to get their businesses organized. So here's some of the big high points for agriculturists, right? FSA eligibility. We're going to talk about that a lot later when we talk about the Farm Bill. Taxes, inheritance, future operations. How do you have it organized now? Do you have any non-fam or farming heirs that are going to be involved or might be involved in the future? That might impact how you set this up. And then just complexity and cost, right? Because I mean, you could go to a lawyer and we could build you the stack of cards of entities, but if you've got 37 entities that makes it impossible for you to operate the place, then you kind of defeated the point. So there's always a level of tolerance for how much complexity you actually want to put in the mix here before you just say that's too much trouble. So told you to be brief, touched it really quick. Moving into the estate plans portion of things. So first thing to know is the fact that you're even on this webinar puts you ahead of about half of Americans. We typically float in the United States between 50 and 60%, sometimes up to 75 of Americans that have an estate plan. So in other words, typically half or more of Americans die without any estate plan in place. So it's important if you have an ag operation that you do get something in place. So kudos to you for even hopping on today. There's that picture of my dog, just so you know, he is my estate plan. He gets everything I own. When someone mentions an estate plan in casual conversation, almost everyone knows of a will, right? We've all heard of having a last will and testament. You should have a will, so on and so forth. That's true. That is true. But I find that most people don't know what all a will can do. So for example, your will doesn't just say, I want all my property to go to Sally. It can do lots of things. It can dictate, yes, your actual property, but all kinds of property, both real property like dirt, housing, barns, whatever, right? Actual land, minerals, and now, of course, there's this whole debate about wind, separate wind rights and all those types of things as well. Water, of course, but also your personal property, right? Your cars, your personal effects, your money, all those things are controlled as well. In addition, your debts, you can control how some of your debts are dealt with, which properties need to be paid off first, which assets need to be liquidated before other assets to pay off any debts that I have. You can control a lot of that in your will. In addition, gifts, if you're going to leave gifts, for example, to any charity of your choosing, your church, your alma mater, FFA, 4-H, whatever it is, you can do that through your will. Guardians, if you have minor children, then obviously you can establish the guardians for those minor children in your wills. That's very important. Typically, when I have a young couple come in, that is the spurring event that has brought them in. The catalyst for them seeking an estate plan is that they now have kids. And, one of them saying, well, they're going to my mom. The other one saying, well, they're going to my mom. Every once in a while, I get a dad thrown in the mix, but usually it's the moms they're warned about. So those are all important things that most people, I feel like, don't realize your will can do. It can also do things about disposing of your remains. How do you want your remains disposed of? All kinds of sensitive things. In addition to that, when we talk about an estate plan, it's more than a will. There are many, many, many other documents that you typically want to consider having in place. So a durable power of attorney, lots of people just call it a legal power of attorney. That's giving someone else the ability to represent you in a legal capacity for all kinds of things. And you can cherry pick, you can make it really limited and say they can only do these things on my behalf, or you can make it very broad, saying they can basically represent me in anything. They can file my taxes, they can deal with my bank accounts, they can deal with my land, they can sign my checks, like they can do whatever, right? So it can be very limited or very broad. But important to have one of those in place if you want the ag operation to be able to function should something happen to you. So there's not this big time delay and then getting a lawyer, getting to court, so on and so forth. This is a document that could really help if you are in some position where you can't function and the farm needs to move forward, right? Now that doesn't work after death. The power of attorney, it terminates upon your death. So once you've passed on to the Lord and Savior, we got to transition to your will or your estate plan. We can't rely on the power of attorney to kind of keep things going. Medical power of attorney is similar. It's giving someone the ability to make medical decisions for you if you cannot. So obviously, if you're cognizant and the doctor can ask you, they're just going to ask you. But if they can't for some reason, let's say coma, one of these crazy college drivers here in Lubbock T-bones me on 19th Street in front of Texas Tech, and I end up over at University Medical Center, and I'm a hospital potato, they're going to have to ask somebody else what treatment I'm supposed to get. The doctor's going to say, we can sever the limb to save the body, or we can give him this experimental drug, or we can do this emergency surgery that's kind of risky. Which one are we doing? Well, they can't ask me, so they got to ask somebody. And if you don't have one of these, Texas has a default order of your family members that it goes in. And so if you want to control who that is and maybe what decisions they can and can't make, you want to have a power of attorney. Lots of times the limitations clients put in there are religious based. So for example, the Catholic Church has many rules about certain medical treatments. So if we ever have Catholic clients, there's some stuff we need to talk about, put in there. An out of hospital do not resuscitate. Most people refer to that as a DNR. So that's, do you want to get respiratory aid from like an EMS person in an ambulance if you go down, while you're out at the gym having your morning coffee and they roll up to pick you up? Do you want them to do CPR or not? A guardian self-designation, that's choosing a guardian for you. So earlier we talked about choosing a guardian for your minor children if you have children under 18, or if they have some type of disability. Guardian self-designation is for you. So if you develop a mental condition or a disability that makes you incapable of caring for yourself or for your affairs, who do you want to be your guardian? Most of the time, when a client signs one of these, it's not because they're adamant on picking who their guardian is. It's typically because they're adamant on picking who their guardian cannot be, who it shall not be. Because you can also disqualify people from being your guardians on this document. And if you disqualify someone on this document and it is a valid document, there's nothing wrong with it, the court cannot and will not appoint that person as your guardian under any circumstances. So they usually draw some laughs. There's typically a lot of mother-in-law jokes from clients at that point. But it is typically the main reason that someone does fill out one of these documents, because most of the time your legal power of attorney we talked about up top will take care of most things, and you typically won't even need a guardian. There are some instances where that's not true, but for the most part, that power of attorney is going to do the trick. So most of the time, if you're going to do one of these guardian self-designations, it's because you want to strike somebody from the team roster. A HIPAA authorization, that's just giving your medical providers a list of persons who can be in the room when they discuss your medical treatments. So it doesn't give any of those people any authority to make any medical decisions for you. It just lets them be in the room. So I typically tell clients, you've probably seen all those Hallmark movies at Christmas where grandma gets hit by a reindeer and the entire little snow globe town shows up to the hospital and are all waiting in the tiny little hospital for the one doctor to come out and say, grandma's fine, right? The reindeer nicked her. We sewed her up. She'll be down at the city hall to do the Christmas celebration by tonight and light the Christmas tree or whatever. They can't do that, right? A doctor is not technically allowed anymore to discuss your private medical information with anybody other than you. Okay, you have to authorize them to speak with anybody else. So that's what that document does. A directive to physicians is about life support, whether you do or do not want life support. Most clients want to fill that out because they want to take that burden off of their medical power of attorney from making those kinds of decisions. So they're making it ahead of time. Appointment for disposition of remains. You can do this in your will, talk about what you want done with your remains, or you can do it in a separate document. The reason that I have clients do it in a separate document sometimes is because sometimes people want weird stuff. And you may not want that in your will, which becomes public record after you die. We take it down to the courthouse. It's down at the courthouse. Anybody can see it. So I've had clients that were complete opposites. In fact, they were husband and wife, complete opposites. She was quite adamant about the ceremony, that, all the religious things we follow. Oh, and about her body, very specific rules about what she wanted done with her remains. Husband was the opposite. He didn't care what they did with the body. He said, throw it in a ditch for all I care. But he was very adamant about the ceremony and the particular music album that was to be played and the particular drinks that were to be served. So I thought maybe none of that needs to be in your wills. Let's do that somewhere else. So that's why you might consider doing one of those. Declaration for mental health treatment. I rarely do these, but if you have a history in your family of mental health issues, it's something you might want to consider. It lays out, if you were to develop Alzheimer's or something of that nature, what treatments you do or do not consent to. Pet trusts, fairly rare, but becoming more and more common. You can actually set up trusts for your pets. Lots of people do it. Not super common, but absolutely possible. And then anatomical gifts. If you want to be an organ donor, there's lots and lots of rules about that. Again, the Catholic Church has quite a few rules. So we usually talk about that. So that's a general estate plan. If someone comes in and wants an estate plan, those are typically the documents that we're talking about. There are others, but those are the big ones, right? So if you're jotting down a list real quick of things you might be thinking about, those are the ones you might want to look into a little bit and just see if you need them or if you don't. You may not need them all. In fact, you probably don't need them all, but you probably need some combination of them. Certainly more than just a will. So what happens if you do have a will and now you've passed? What does that mean? So one big misconception is people think that the will is automatically this magical document that just handles everything. But that's not true. The will has to be put through the court system to mean anything. So you have to go probate the will. So you have to take it down to the county court, file a court case, an actual probate court case, go have a hearing with the judge, and the judge has to approve the will and say, yes, this is a valid will under the laws of the state of Texas, and I am approving it, admitting it into probate, meaning it is now a binding will, right? And so that is what the probate process is. So again, this only comes into play once you're deceased. Some states will let you file your will ahead of time during life and have it basically like pre-filed. Texas does not do that. We cannot file your will until you are dead. In fact, we have to give a death certificate and prove that you're dead most of the time. Things to know. Probate is very state specific. So probate in Oklahoma is different than Texas, is different than New Mexico, is different than Kansas. Okay. They're all different. They all have their own systems. And some of them have a means of recognizing the other states. That's called ancillary. That's what's down there in the bottom right corner. So if you have things across the state line, so let's say you're from Pampa, where I'm from, and you're grazing cattle across the eastern border over in Oklahoma, and you pass away, well, Oklahoma is going to have jurisdiction over those cattle. So if we're going to go do something with those cattle, we may have to go to Oklahoma to get a court order from them, and then we're going to have to do a court order in Texas to deal with all your Texas property. So we want to plan for that ahead of time. If you're doing an estate plan, we definitely want to know if you are constantly holding property across state lines. Certainly if you own property across state lines, you got a house or you got some land over in New Mexico or something, we definitely need to know that. There are ways to avoid needing multiple probates in multiple states. But if you find yourself in that position, you're going to be relying on something called ancillary probate, which is where you take the probate from the original state and you go do it again in another state. And they typically have like an expedited way of doing it because they don't typically make you start back at square one because you already did this whole song and dance once in your home state, but there's some special rules. There's also lots of types of probate. They're not just one type. And which type you're going to use depends on whether you have a will or not. What does your family tree look like? What do your assets look like? Are we just trying to pass land? Are we just trying to pass cash? Are we trying to pass both, plus a bunch of cars or trucks or equipment, or what are we talking about? And then debts. Debts tends to be a really big one. So do you have debt? Do you not? Is it secured debt, like a ag credit lien against your land, or is it an unsecured debt like your Costco credit card? Right? What are we talking about? And all of those things kind of come together when someone walks in and tells me, dad passed, we need to deal with the estate, here's his will. Those are the things we immediately start talking about. I'm like, okay, can you give me an idea of what he owned? Land, cattle, equipment, the house, the cars. Let's just get an idea. Debts. Do you know if he had a lot of debts? Did he pass away in the hospital? There are going to be big hospital bills coming in a few months. Did he have his operating note out with the ag credit this year? Did he not? That kind of thing. So we're going to do a real quick overview of some of those. We just talked about this, state versus ancillary. Here's a quick overview of the Texas options of probate. Okay, so if you go probate a will, meaning I have a will, okay, I'm either going to do dependent or independent. 9 times out of 10, if somebody wrote a will, they made it an independent administration, the one on the right. That's because it's less time consuming, less confusing, and the executor, the person named to take over the estate, has power to deal with the estate without having to go back to the court. They are independent of the court. So once the judge appoints them and puts them in that position, they can just go forth and do what they need to do with the will and the estate and just keep going. And we don't need to go back to the court to ask permission to do stuff over and over and over. Dependent administration is the complete opposite. The executor is, and we actually typically call him an administrator at that point, but it could be an administrator or an executor, it kind of depends. But anyway, they're dependent upon the court's authority. So in other words, if they're like, hey, we really got to sell the east whatever acres because we got to generate the funds to pay the taxes or whatever, they'd have to go to the court and ask permission to do that. Or if they wanted to pay off a big debt, there's a lien on the tractor, we want to liquidate the bank account to pay off that debt, they'd have to go to the court and ask permission. If they want to go ahead and distribute the property, they're ready to distribute it to the heirs, they got to go to the court and get permission. So they have to keep going back to the court. Now, the reason you might do a dependent administration, and we have optionally done that before for clients, is either A, the executor, the client, wasn't prepared to handle all the business operations of the decedent. They owned a coffee farm in another state, and they owned windmills in another state, and they owned oil in another state. And it was just like a very complicated thing. And they're like, I feel like I don't have the ability to do this properly. I would like a court to basically babysit me through. Okay. Or if there's going to be a fight. If we need a referee, we need the judge to play referee. Sometimes that's a reason to do a dependent. Muniments of title, most states don't have this. Texas does. We casually call it our express probate. So if you are just trying to pass land, okay, so only land. We're not trying to get to bank accounts. We're not trying to get to cars. We're not trying to get to equipment. We're talking about dirt. Everything you own, we can go down to the courthouse and find a deed for it. Okay. And there's no unsecured debts. So if it's debts on that land, like a lien from Ag Credit or something, that's okay. But like the Costco credit card, like the medical debt from the hospital, they haven't filed a hospital lien yet. So any unsecured debts, those cause a problem. So if you got those, you can't do a muniment. So if we're really only talking about land, that's the only thing we're passing, and we're not really worried about debt, we can do a muniment. In which case they will admit your will. It gets treated like a deed, and it essentially transfers the land to the heirs, and we're done. No executor is appointed. There is no administration of the estate for a few months after the hearing. That doesn't exist. We don't even open administration. The probate and the entire estate are opened and closed all in one hearing in about a 5-second span, and you're done. And it's a much, much faster, quicker, easier process. But like I said, you got to fit within that little pinhole requirement that it applies to your estate. Small estates affidavits, those are typically used if you die without a will or we can't find the will. That happens sometimes because Texas is still one of those states where we require usually the original physical signed will. We do not at this point accept digital wills in Texas. Some states do, Texas does not. And I typically need that original. So if you did a will back in 1950, we're going to need it in 2024. If you pass away, we would need the actual will. We can probate a copy, but it's more difficult. So there's that. The small estate affidavit is court-approved affidavit that you file and record it with the courthouse. It typically will go ahead and pass your property. However, this is the big catch, and people get this wrong all the time because they'll Google it or find it. A small estates affidavit only passes some property. It can't be used to pass all your property. So for example, on land, it really only passes title to your homestead. So your house and the acreage around your house. So I think it's up to 200 acres now in Texas for rural, but that's it. Everything else cannot pass under the small estates affidavit. We'd have to go do a dependent administration and get the court to pass it that way, or do an affidavit of heirship, which we'll talk about in a minute. Temporary administration, those are really rare, but that's if there's some emergency, right? We don't necessarily need a full-blown estate opened for, the next several months to take care of something, but there's an emergency. We got to take care of something right now, right? We need somebody to sign off on the ag note right now, kind of thing. You can get a temporary appointment of somebody. They only last 180 days. They have really limited authority, but it's kind of a Band-Aid to fix an emergency. One thing to note, we talked about the ancillary situation. If you had to cross the state line, like I said, the other states will typically accept the probate from the original state. So let's say we did your probate here in Texas, but you had property in Oklahoma and New Mexico. Well, we'd have to take that Texas probate over to Oklahoma and New Mexico and ask them to admit it under their ancillary rules, which are different. Most states, like I said, don't have a muniment of title. So if I did your probate here as a muniment of title, when I go take it over there, they're going to say, what's this? And I'm going to say it's a muniment of title. They're going to say, what the heck's a muniment of title? And they're going to make you start all over. So that's another thing I ask, like your kids up front. I'm like, well, if dad or mom own land across state lines and we're going to have to go across state lines, even if we could do a quick and dirty probate in Texas, we may want to do the full-blown probate because you're going to have to take it over to another state anyway, right? So you kind of got to think a few steps ahead. Now, what if you don't have a will? I told you half of Americans don't have one. So what happens to them? Well, we talk about heirship and intestacy. So first of all, we got to go have two different things opened down at the courthouse. Lots of times they'll let you file them together and run them together, but it's technically two different court proceedings. One is an heirship. And if you've ever turned on like Bravo TV or been sitting in a doctor's office in the middle of the day and there's all those TV shows on and people are showing up and saying, well, I'm his son. He didn't know about me, but I get half of his stuff. That's an heirship proceeding. That's where the court determines who your legal heirs are. Because that's one thing your will does, is it tells us, I'm Garrett, these are my kids, right? And if we don't have that, then we got to figure out who your kids are. So we have a court hearing to do that. And there's another attorney involved that gets appointed to represent your kids or maybe kids. And we got to do kind of like ancestry.com court hearing type thing and figure out who the heirs are. crazy stuff can happen, like people kicking down the back door and showing up and waving a hand and saying, I'm a kid. That doesn't happen a lot, but it can. So there's that. Then intestacy is the distribution of your estate established by the state of Texas. It is in the estates code, and it says, all right, if someone dies without a will, this is where their property goes. The end. Right? And so the law will decide your inheritance plan for you. And depending on how your family tree looks, that could be very different. Texas kept a lot of old English law when we passed our estates laws in Texas. So we have some very old distributions that may not match with what a modern family may look like. So for example, stepchildren, if they're not adopted, they will get nothing. Things like, there's lots of different scenarios I could give you, but in essence, if you don't write a will and tell us who you want involved in your estate, the law is just going to decide for you. An affidavit of heirship is another one that we use typically when there isn't a will, and we're just trying to clear up the title records to say, lots of times this happens with minerals, right? We're saying, oh, well, Garrett died 20 years ago. We're trying to get his minerals straightened out because there's payments held up at, whatever Conoco or whatever, and they owe us all this money, but they're not paying it to us because there's no probate. You can typically do an affidavit of heirship to try to get that cleared up. Now, here's a few things to know. It is just an affidavit signed by 2 witnesses and an affiant saying, here's the person that died, here's their family history, here's who their heirs are. We swear that's true because we know this family, basically. There's some other things in there, but that's the gist. You record it like a deed, but here's the catch. It has to sit on the property records for 5 years, uncontested by anybody, before it's technically considered to be authoritative proof of the title to the property. Now, I'll be honest with you, every time I've said that to any group, I've said that to bank groups, real estate groups, ag groups, almost every time I get this like large gasp as if some awful horror event is happening in the back of the room, because no one waits the 5-year period. That is what the law says. In my experience, oil companies will take it as soon as the ink dries. Banks will typically take it 16 months or so, 2 years maybe. Certainly more closer, not 5. And some other groups will typically take it somewhere in between those two. So I've never heard of anyone making you wait the whole 5, but just so you know, it's up till year 5, that thing can be contested and it's not technically proof of ownership. Then there's lots of ways to pass your property without a will at all, to pass them under contract law, not even estates law, just to pass them automatically, or bank law. So life insurance is one. If you have a life insurance policy and you have named beneficiaries, they probably had you fill out a form that said designated beneficiaries and you listed who you wanted the money to go to. That will pass automatically. That does not go through the court system or your will. So even if your will said, I leave the funds from my life insurance policy to Garrett, that won't matter, because if on your life insurance you put my beneficiaries Becky, Becky's getting it. I'm not, right? Because it's going to pass under the terms of the policy. Same with IRAs, 401ks, things like that, where you have designated beneficiaries for those retirement accounts, same concept. Some bank accounts you can actually make automatic, or what we call non-probate, meaning they don't require your will. There's pay on death accounts, which do exactly what they say, pay this money to this person upon my death. Very similar to life insurance and IRAs, you designate someone to receive it. Joint accounts with rights of survivorship. This is important. There are lots of different types of joint accounts, and I feel like banks do a really poor job explaining that. So a joint account means that 2 people own it, and you own it in whatever proportion of money you've contributed. A joint account with rights of survivorship means the same thing, except that when one of you dies, the survivor automatically gets the rights to the money. So it's survival of the fittest. Whoever lives the longest gets the bank account. Okay, that's important. So usually for married couples, that's a very useful tool to allow your spouse to get full control of the bank account when you die, if your intent is for that money to go to your spouse. Some deeds can do the same thing with land. Transfer on death deeds and ladybird deeds both can transfer land at your death. We're going to cover those in a little more detail in a minute. And then living trusts, right? So if you set up a trust now during your life, it's already in existence, then it doesn't require your will and it's already functioning when you die. Now, if you do a testamentary trust, meaning one, it's just in your will, that trust doesn't exist until we go do probate. That catches people all the time. It's like, well, our other lawyer set up a trust. We don't need to do, my kids won't even need this will, right? And I'm like, well, no, because your other lawyer put the trust in your will. That's a testamentary trust. It's set up by your last will and testament, meaning we would have to go to court and probate the will for the trust to be created. So if you want the trust to exist now and be putting assets in it now, or to list it on a life insurance policy or something like that, we need to set it up now outside of the will. Transfer on death deeds and ladybird deeds I mentioned just now. I'm not going to go through all the details. There's several slides in here on those, but there's a trick that y'all can learn on much faster and probably more fun than seeing a bunch of slides that I'll give you in a minute. But the short answer is transfer on death deeds is a deed you actually fill out and record now that says, on my death, I want this acreage to go to Garrett or whoever, right? And when you die, that property transfers. Typically, those people file a little affidavit that just says, hey, he's deceased. So this will or this deed now takes effect. But the deed is not effective until you die. You can revoke it. You can pull it back out of the records. You can still sell the land to whoever you want. You still have complete control of the land. It's just saying, if I die and I still own this land when I die, I want it to go to these people. The downside is you want to be careful about that if you have a lien on, or no, actually this one's okay for liens because you didn't transfer anything. Strike that. This one's perfectly safe if you got a lien because you're not transferring anything until you die. But you still want to be careful about it because there are rules where, like a creditor, if you have creditors, they can potentially claw that land back into your estate to pay your debts. So it's not foolproof. There are some catch-22s. The other thing is this is relatively new. It was created by statute and it's pretty modern. So there haven't been a whole lot of lawsuits challenging them yet. So whether the statute stands up against a judge, who knows? But so far they've been functioning. Ladybird deeds are similar but different. A ladybird deed is the colloquial way that we call an enhanced life estate deed. So if you ever heard of a life estate deed, that's what this is, but it's enhanced. And the reason it's enhanced is because we reserve a whole lot of rights for you that you normally wouldn't get in a life estate deed. So a life estate deed transfers to a recipient what we call a remainder interest. So you do go ahead and transfer some portion of your ownership of land now. Unlike the transfer on death deed, you are actually giving something up right now when you do one of these. So if you did a life estate deed to me for the ranch and you said, I'm granting Garrett the remainder interest, or I'm granting this land to Garrett, but I am reserving for myself a life estate. That means you still get to own it for the remainder of your life, live on it, utilize it, use it. But when you die, I get it. I'm holding the anchor, the remainder interest, okay? The one thing to watch out for on these is that because you are technically transferring something at this point, if you have a lien on this property, your bank could potentially call your note and say, hey, you sold our collateral. And you're going to come back and say, well, I kept a life estate. I still have control of it. And they're going to say, we don't care. You weren't allowed to transfer any ownership interest, or we could accelerate your note. We're accelerating your note. You owe us the money. So if you're going to do one of these on land you got a note on, we might want to talk to your bank first. Lots of times they'll agree, but you got to jump through the hoops there. You can revoke these. You can change your mind. You can pull them back as long as you said that in the deed. But just know that's one thing. These are much more established. They've been around since like the 80s. Maybe even longer than that. I could have that wrong. They were established by common law, meaning attorneys just started doing them and courts have blessed them. But they've continued to bless them ever since. So you'll find many, many, many of these in the deed records. They're pretty well established. If you want to learn more about those, the full nitty gritty, our good friend Tiffany Lashmet that everybody knows over at Ag Law in the Field podcast with the Texas A&M AgriLife Extension. She did a podcast episode on these with me a few years ago. And we go through all the details and comparing them on a high level, real down to the nitty gritty on what the distinct differences between them are and things like that. So you can check out that episode for that. Trust, I'll touch real brief. Lots of people have heard of a trust, but they don't understand necessarily what it is. When you put something in a trust, you're actually splitting the ownership of that asset. So if you put your land in, let's say, the Couts Family Farms Trust, I'm splitting the ownership and I'm saying, okay, the legal title to this land is now held by the trustee of this trust, whoever that is. The equitable title, meaning the benefits from it, the rent, the money, whatever, that goes to the beneficiaries of the trust. They own the equitable interest. So you got the trustee, who's technically the record holder, on the records, on the title records, has the title to the land, controls the land, but is controlling it for the benefit of the beneficiaries who are supposed to get all of the economic benefits, right? And then there's lots of different types of trusts, many, many types. But there's revocable and irrevocable, meaning we can cancel this thing or we cannot cancel this thing. It's a one-way street. Typically, if you want tax advantages, you have to go with irrevocable. And living versus testamentary, we already talked about that. Living meaning you're setting it up now while you're alive. Testamentary meaning you set it up in your will and it's only going to come about when you die. There's lots of specialty trusts in Texas, like land trusts, special needs trusts. If you have children or anything with special needs, they can potentially still qualify for government benefits, even though they have a trust. 142 management trusts are typically set up by judges and courts to manage property for people who can't necessarily manage it themselves. Pet trusts we talked about for the benefit of a pet. Directed trusts are new. Those are ones that there's just you can set up a way in which the funds are specifically directed to certain purposes, kind of thing. And there's a whole lot of rules and strings you could tie to the trust. So some quick pros and cons of trust. Pros, they can have spendthrift provisions, which means creditor protections for both you sometimes and for the beneficiaries that are going to receive the trust property later. They're non-probate if they're a living trust. Like I said earlier, don't have to wait on the will. They can potentially avoid partitions of your land in some instances and keep the family farms together. They're very helpful for blended families if you do have those, second marriages or stepchildren or adopted children or anything like that. Interstate use, meaning that whole ancillary probate thing we talked about where you may have to cross state lines and all that, far less likely to be an issue if your stuff's in a trust. And many, many more, lots of pros. The cons, they can kind of get complex, as you can tell. There's a lot of different ways they work. You got to come see a guy like me, pay us some money to set it up, take some time and effort. The cost associated with that, oversight, you got to keep up with them every year. They're going to have a tax return. They're going to have, probably K1s from the income to put on your tax return. They got to file taxes, probably got to get your CPA to look at it. I mean, it's kind of like starting a business. There's annual stuff you're going to have to do. So here's some quick tips and tricks on all that stuff we just talked about. That's the whole, you now understand the probate process of Texas. Just some quick ones to remember. If you got debts, muniment of title's probably out. If we have any missing or unknown heirs, then remember there's that whole 5-year limitation on the affidavit of heirship. They may show up like a Bravo TV show and cause a little bit of a ruckus. Rights of first refusal, we didn't talk about. I'm going to be presenting on this later this year for another group. It's my research project for the year. Hope to get published on it somewhere. But the deal is, rights of first refusal, you've probably heard of, and that's where, you've given someone the right to buy your land if you ever decide to sell it, right? That's a very brief way of saying it. Here's the problem. Lots of people want to put that in their wills. They want to say, I'll leave the ranch to the kids, and if any of them want to sell it, there's a right of first refusal for their siblings. They got to sell it to the siblings first. That's all well and good. Technically, that works. Here's the problem. There's a huge court split in our state on whether that is considered valid notice to somebody who shows up to buy the ranch or not. Some courts say it is notice. They're bound by that right of first refusal. Half our courts say, no, it's not. That's not in the property records. That's in the probate records. Those are different things. So big split right now, big mess. We're working on it. I'm working on it. So anyway, just know rights of first refusal are a very useful tool, but there's some special things we need to do to make sure it's going to work. Ancillary probate we talked about, trusts we talked about, title policies. Just know we could do a lot of stuff with moving your land around, but if a title company is not going to give the next generation a title policy on it, or they're not going to let a potential buyer get a title policy, that's a problem. And title companies essentially do what they want. So they're, as we call them, little fiefdoms, and their favorite phrase is because we say so. So I could talk to them blue in the face and tell them this is legal. Here's the statute. Here's the law. This is how it works. And they can say, well, that's great. We're not giving a title policy on that unless you do it our way. And that's typically how it is. So we either just go to a different title company or we bend the knee and try to make it work for them. So that's the probate process. Take a deep breath. I know I need to. What I want to start talking about now is the second half of all this and the kind of the end of it, the farm succession stuff. This is specific to ag operations. Everything we talked about before can be any estate, no matter what they own. They can own an ice cream shop. They can own anything. But for a large ag operation, this is kind of some specifics we need to pay attention to. Okay, so we got the Farm Bill coming up. Everybody knows about the Farm Bill and the ever-moving target of the Farm Bill. What you should know is there are always fights in the Farm Bill about farm succession planning, always. And amendments are always put forward on how to deal with that. And most of the time, they get sacrificed at the 11th hour for more funding for one project or another. The latest time that happened that I remember was 2018 Farm Bill. There was a big provision that was going to be put in. It's going to be very helpful for estate planning for farmers. Got traded at the last minute, as it usually does, and failed. When I worked on the Farm Bill in 2013, same thing. And so just how it happens. So we're not going to talk about, there's kind of 3 buckets. We're going to talk about farm succession planning. There's the fields at the top, as we call them, which is the light stuff, like dealing with our oldest son, John, who's a little sensitive about the farm, right? That's all family dynamic stuff. We're not going to talk about that today, but it's important. We're talking about some finances. That's obviously real important. And then the actual succession of the farm. How do we keep it running with the next generation? Now, if you're sitting here thinking, now wait a minute, I didn't know we were going to be talking about taxes and math. Don't worry, I'm a lawyer. We're terrible at both of those things unless you're a tax lawyer. So I'm going to keep it very high level, frankly, for your sake and my sake. But there are two taxes you really do need to know about. There's the estate tax, which I'm sure many of you heard talked about recently because it's all over the news at the moment. That only applies when you're dead. Okay, there is no estate tax assessed on you until you're dead, and it's assessed against your estate. So it's not going to be you who ends up paying it. It's going to be your kids. Okay. Then there's the generation skipping transfer tax. That applies the whole time you're alive. And they paired those two things together because the generation skipping tax was meant to fill the holes that the estate tax left in the US budget. Okay. So I'll tell you how those kind of play. So here's the estate tax. Currently, the estate tax is at $13.61 million per person. So in other words, if you don't have $13.61 million worth of stuff, you do not owe the estate tax. If you do have $13.61 million or more of stuff, you do owe the estate tax. And when we talk about capital E estate for IRS tax purposes, that means everything you own. And even if I legally have moved something out of your estate, that does not mean it's out of your capital E estate for tax purposes. Those are two different words. And so that catches people off guard. So for example, if you got a big old fat life insurance policy and I'm like, oh, it's automatic, that doesn't go through your will, we don't have to worry about that. The IRS says, well, that doesn't matter. That was value that they passed via their estate. That counts. So if you got a $10 million life insurance policy, you just hit $10 million on the IRS's calculation here. So there's some stuff potentially. There's ways to deal with that, but you got to pay attention. They're counting more stuff than I am from a legal standpoint, is my point. So $13.61 million for this year. Next year, it's going to go up to $13.99 million because it moves up with inflation. They just put out those numbers like a few weeks ago. So it's $13.99 million for next year. One important thing y'all should remember on here is portability. That is where if you die and you didn't use your full exemption, so let's say you die with $10 million worth of assets. That means you left $3.6 million or next year, $3.99 million on the table. You can potentially port that almost $4 million extra to your spouse. And now your spouse can die with $17.9 million. They get your extra $4 million that you didn't use. And so it can help cover them because now their estate's going to go up, right? Because they're probably inheriting a lot of stuff from you. So if they had 10 before you died, and then they're going to get the 10 that you left them, well, now they're at 20, right? So we're in trouble. So bumping theirs up with whatever you had left can help them close the gap or sometimes even avoid the tax altogether. So portability is very important. To get portability, you have to file a tax return when you die. Your estate must file a tax return. So your kids, when they come do the probate, we always tell them, hey, look, even if mom and dad died with $5 million, nowhere close to the limit, have your CPA file an estate tax return so that all that extra can be ported to mom, ported to dad, ported to, whatever. So that's important to know. Also important to know if all out crisis hits and you do find that you do get assessed in estate tax, your kids, or your parents pass away, you're dealing with it. There is a way for farm and ranch properties to use a special loan program to borrow the money to pay the estate tax instead of liquidating the farm to sell, right? To make the money to pay the tax. That's typically what happens. You end up selling half the ranch to get the money to pay the tax because the tax is due within 9 months after death. So they issue a statement. They say, here's the total. You owe it in 9 months, lump sum. But if it is farm and ranch, you can do these installment payment programs and pay them out in installments. And it has to qualify, and there's all these other rules, but there is a special provision for farm and ranch. Now, here's the rub. The state tax currently is set at that really high limit because of the 2017 Tax Cuts and Jobs Act. It took it from 5.49 million up to 7 million plus inflation, which is how we've now gotten to the 13.61. So, well, I'm sorry. It used to be at the 5 million. It bumped it up to 13 million. I take that back. Bumped it up to like 11 million and then plus inflation. So that's how we got to the 13 million. But that law, the 2017 Tax Cuts and Jobs Act, expires next December 2025. So if Congress does nothing, then come January 2026, the limit drops back down to the prior level, which was 5.49 million plus inflation. So it's going to come out to about 11 or 7 million. So in theory, in 2026, this could drop from 14 million down to 7 million. Going to cut in half. We have no idea what's going to happen there. Congress could extend it. Congress could not extend it. They could just ignore it. Who the heck knows what they're going to do, especially post-election. We don't know. So we're just having to wait and see. Now, generation skipping transfer tax, that is for when you transfer property to the next generation or 2 generations below you because you're trying to avoid the estate tax, right? So what was happening is really wealthy people on their deathbed were saying, well, I'll just start gifting all this stuff to the grandkids right now. Give me a deed. Deed. Well, so the government was like, well, you can't just do that, right? So we're going to do this generation skipping transfer tax thing. So you use the same limit as the estate tax, that 13.61 million, 13.99 for next year. Okay. And if you give property over the gift tax limit, which this year is $18,000 a person, next year it's $19,000 per giftee, meaning you could give $19,000 to 20 people, and that's totally fine. That doesn't count against anything. But if you go over the 19,000, it starts counting. But when you give this, there is if you meet the GST tax, then you owe a flat 40% tax on the gift. Okay. So here's an example. If you got grandparents, right? They got 2 kids, and each of those 2 kids has 2 kids. Okay. And grandparents want to give a bunch of money to kids. That's okay. Or land or whatever it is, assets. That is not a generation skip. You didn't skip any generation. You gave it to the next generation below. That's a non-skip person. Okay. But then those grandkids are going to give or your kids are going to give a portion of it to the grandkids, that same gift. Well, now there's a skip because a portion of your gift got passed on to the grandkids. And there's lots of ways that happens with gifts and trusts and things like that. Where you're like, oh, this is for my kids. And then after them, it goes to the grandkids, yada, yada. That could be a skip. Okay. Or if you just give it straight to the grandkids, that's a skip because you skipped the kids in between, right? On any of those, you're going to owe the tax. Now, there's lots of exceptions. One, again, if you're under the gift tax limit, if it's under the 19,000, doesn't matter. If it's for medical expenses and you pay them directly to the medical provider, those are exempt. If it's for education expenses and you pay them directly to the educational institution or into like education account, like 529 accounts, that's exempt. So if you're going to pay their Texas Tech tuition, that's probably fine. If you're going to pay their UMC bill, that's probably fine. But you got to pay it directly to the institution. You can't give it to grandson Johnny, who's then just going to use it for those expenses. That doesn't work. And this is just an example you can look at later that shows how if you were given up to that total amount, which taxes you might owe depending on who gets the money. So the takeaways here, you're going to need a CPA, you're going to need a lawyer when we're talking about taxes and your estate. And there's lots of ways to plan around these and to plan for them and to deal with them, but you want to do it ahead of time. Now, last but not least, I want to talk about some specific farm succession stuff with the USDA. I am not going to cover all these. I'm going to go real fast. But when we're talking about payment eligibility, if you're on any FSA programs, CRP, conservation, any of that type of stuff, that is really going to heavy-handed play a role on what we can and can't do in planning your estate. Because for the average Joe that comes in here and says, hey, I just want to make sure my kids keep this land together, and I want to make sure if they want to sell, there's some rules on who they can sell it to. I want to make sure it's easy for them to keep owning it and then keep collecting the money. But really, you know, these two kind of run it and these two kind of don't. What do? An LLC. Every day of the week. I'm going to tell them probably an LLC. Unless there's some tax reason that's not going to work for y'all, that's the option. You can't do that with a farm because if you do that, you are capping your FSA eligibility. You are kneecapping your FSA eligibility. And so that's why you see most farms and ranches operate as general partnerships because that is what the Farm Bill prefers. So hopefully that will change. There is, again, a round of legislation and amendments to open that up. There are also counter amendments and counter legislation to go the opposite direction and make it even harder for ag operations to use entities. And so we have no idea how that's going to shake out. But that's been the fight every farm bill that I can remember. So we'll see how it goes. Y'all are probably familiar with these, but to get FSA eligibility, you got to have what's called left-hand contributions and right-hand contributions. And there's lots of rules about what qualifies for those things and what does not. But that's how you reach actively engaged in farming, which means you're eligible for FSA payments. There's lots of exceptions. I have slides for all those. We won't go through them. The main ones you'll probably need to know about are military service and cash rent tenants. But I'm happy to send those later. So we'll skip through most of those for now, just for time's sake. But what I want to talk about is this one. There's also the family exception, which is, oh, by the way, if everyone in the entity or everyone involved in the operation are family members, then we're basically going to say they all qualify, right? Huge benefit for small family farm and family owned operations. But that definition is also always in play with all these amendments and laws coming through. So for example, the current one going through is the Farm Program Integrity Act filed back in 2023, which is still in this current session by Senator Grassley and Sherrod Brown. It essentially does the opposite. As opposed to allowing entities to be used, it pushes back the other direction. And it says, okay, we'll leave the current $125,000 income cap for operators, but we're going to add a new $250,000 cap for the whole operation. So no matter how many individual operators are in it that are under the limit, if cumulatively the operation is above the 250, no payments. Additionally, there's a new cap on $75,000 for the marketing loan programs. And they want to change that definition of actively engaged in farming. Right now, you have to have at least 1,000 hours of labor or an unqualified amount of management. They want to change it to an and requirement, not an or requirement. And they want the management to be in some kind of combination. So 50% commensurate share of the total farm labor and management. So in other words, making sure everybody's getting their hands dirty is the point they're trying to get to. They do leave the family exception alone, which is good. But here's the big one that's the kicker. Right now, general partnerships don't get capped, right? The individual income cap still applies, but they look through the partnership, and instead of cutting one check to the partnership, the FSA can cut checks to each individual partner as long as each partner qualifies. So you could get 3, 4, 5 payments as long as each person qualified. If you put that same operation in an LLC, you're going to get one check, even though you changed nothing. All you did was change the operation from a partnership to an LLC. You're only going to get one check. So you just cut the farm income from 4 checks to 1 check, right? This bill would apply that same idea to partnerships, meaning it counts as an entity and gets a single cap, as opposed to each partner getting payments. So we don't know where this is going to go. It's been filed. Some version of this bill has been filed, like every farm bill for the past several farm bills. So we'll see where it goes. One point on the Corporate Transparency Act, I'll probably not care about this. It's going to be very, very brief. If you filed an entity or own an entity, so if you do have a limited partnership, an LLC, a corporation, there is a new federal law that was, up until last week, going to require you to file this beneficial report to the Treasury, the U.S. Treasury, about who owns that entity and give them a copy of your ID and a bunch of information about yourself. But the Eastern District of Texas, Federal Court, Eastern District of Texas, issued an injunction against the law last week, about 12 days ago, actually, putting an injunction nationwide that we didn't have to follow. The deadline was December 31st, so here in just about 2 weeks. They have put an injunction against that. The federal government has appealed it to the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals issued an order expediting briefing, meaning they want to hear it very quickly. In fact, I believe those briefs were due yesterday. The government asked for a stay of the lower court's order, meaning please let the law go forward while it's being appealed. So we want to enforce the December 31 deadline. So far, the Fifth Circuit has not granted that stay, but they could at any moment. So we don't know if they're going to or not. We have no idea. If they grant the stay, meaning we do have to file these reports, it is likely, though I cannot guarantee it, but it is likely that the Treasury will issue some additional grant period of time for people to get caught up, since this order has been so close to the deadline. That's what we're anticipating to happen. Can't promise that, but that's the anticipation. And then here's some just brief things to remember. Overall, if you've got non-participating heirs, we probably need to talk about if you want them involved in the operations going forward, or if you just want to give them some type of alternate asset. Right? Instead of giving them their 1/3 of the ranch when you know they don't really want it, do you just want to go get a big fat life insurance policy and give them money instead, and then let the other 2 kids that want a farm keep the farm? Maybe you do, maybe you don't. Structured management. Well, maybe, 2 of them don't really participate, but they still want to own it with sibling that wants to farm. So maybe we just set it up where they all still co-own it, but that sibling is the one in control. They manage the farm. They make the decisions, right? The others can have economic benefits from the farm, but that person has all the control, right? Structured sales, again, that's right of first refusal type things. Do we want to make it to where they have to sell to each other? How do we do that? What's the practical realities of doing that? Can we do that? One big issue that all those things are meant to address is partition, or as I call it, the disappearing farm effect. So in Texas, you have a constitutional right to sever your land from any co-owners you own it with. So if you co-own land and you don't want to co-own land anymore, you have a constitutional right to split that land off. And I'm sure many of you have probably come across a partition in your life because they're fairly common, at least in ag families, because we tend to inherit property as co-owners with our siblings. That can cause a lot of problems because lots of times the farm ends up getting sold. And there's two different partition statutes in the state. We have a new one from about 2017 called the Uniform Heirs Partition Property Act. I butchered that, but it's the Uniform Partition of Heirs Property Act. That's what it's called. So if your heirs, meaning y'all are siblings or something, related family that inherited land, and now you want to partition it, there's special rules to try to help keep the farm together, like buyout provisions, rights of first refusal, required appraisals, things like that. But it's still a partition, and there is still a chance it gets sold. So that can split up a lot of farms. And there's a lot of ways we can deal with partition, but it tends to be the biggest specter that breaks up the family farm after a death. Like I said, it's an absolute right. Texas Uniform Partition of Heirs Property Act. I actually just emailed a bunch of ag attorneys and law professors just before I hopped on here. A bill was filed in the Texas legislature this current session about to start, adding a bunch of amendments to that Partition of Heirs Property Act, beefing it up some because frankly, it's a new law and I have yet to meet one Texas attorney that has had a successful case using it. I filed 3. All 3 of them ended up settling or dropping because the court couldn't even figure out how to use the statute. Like we were filing motions to the judge saying, please do this thing that the statute requires you to do, judge. We don't, and he'd call us and say, well, what am I supposed to do? And I'm like, I don't know. It says it's the court's responsibility to do X. I need you to do X. So no one has really figured this thing out, in my opinion, but there's a bunch of new provisions that might go in this session that will beef it up some. So. And with that, I think I'm done. I took over a little 3 minutes over, but I am more than happy to answer questions if anyone has one. And I apologize for the quick speed and the low breath, but I'm always happy to chat if you ever need anything.
Thanks, Garrett. We'll let everyone have about 30 seconds to a minute. If you have any questions, feel free to drop them in the chat box or the Q&A box. And if you have a question and don't get it answered today, please feel free to email education@tscra.org and we will make sure to get you in contact with Garrett. And it does look like we have a few compliments that everyone is very grateful and very appreciative of you taking their time today, Garrett. We do have a question. So if you haven't filed the BOI yet, should you by December 31st?
It's a very good question. And frankly, it's kind of like a medical thing. If you ask someone else for a second opinion, you might get a different answer, but this is our firm's approach. We are telling clients to continue preparing their filing, have it ready. There's no harm in collecting that information. It's useful information for you to have organized anyway. But I wouldn't hit submit on it, frankly. I wouldn't turn that over unless I have to. So I would have it ready, but I wouldn't submit it until you find out. What you need, the information you need collected for that beneficial owner report is the driver's license or passport or other government ID of every owner of the entity. A beneficial owner can mean lots of different things. The main definition is if you have 25% ownership or more, or if you have substantial control. Big definition there. Lots of people have substantial control. If you're looking at this for the first time, I will give the Treasury credit. The website they set up, and FinCEN is the Department of the Treasury taking care of this, the Financial Crimes Enforcement Network. They're responsible for this bill. They have a website. It's very good. And on that website, there's a PDF called the Small Business Resource Guide or Small Business Compliance Guide. It's great. Has lots of visuals in it, breaking down how you figure out who the owners are, has checklists you can use. It's actually very, very good. So if you're starting from scratch, this is the first you've heard of it, go download that and it will help you out a lot.
Next question is executor in charge of or responsible for cattle after someone passes away?
Yes. So we constantly tell people, kids, it's kind of fascinating to me. Kids want to fight about who the executor is. You don't want to be executor. It's a really crummy job. You're responsible for gathering all of the assets of the decedent, paying the debts, and distributing the property once the debts are paid, as well as dealing with the lawyers and the CPAs and filing the taxes and going to the court. So it's a job. And so, yes, they actually are responsible for taking control of all the assets, all the operations, everything upon death, unless your estate plan has been set up to avoid probate. So, for example, if those assets are in an LLC or in some type of entity, then whoever gets that control of that entity under its rules, they will continue to control the cattle and the operations, not the executor. So it depends how it's set up. But if you just have a will and that's all you have, yes, your executor will have to take control of everything.
How hard is it to prove neglect of executor duties?
Yeah, so that's called a breach of fiduciary duties. So that's actually the lawsuit that would get filed against an executor if an heir believes that they did wrong, took property they weren't entitled to, or they didn't pay off the debts, or they didn't follow the will, they breached their duties in some way. That's called a breach of fiduciary duty. It depends what the breach is, how hard it is to prove. They do, if they're an independent executor, they do get a lot of latitude. They have a lot of authority. I'd say one that's pretty easy to prove is if they point blank didn't follow the will, right? I mean, that's a breach. Some that are harder to prove that some heirs try to bring is, well, I thought I was going to get $1 million and I only got $800,000. What happened to my $200,000? And we fight and fight and fight. And then it turns out that was everybody's portion of the taxes, the probate bill, the operating note to capital credit. Like it was used for legitimate expenses of the estate. Those are much harder to prove because there are lots of things the executor does have to pay out of your inheritance.
Okay. We'll give everyone another 30 seconds just to ask any last minute questions. Okay, going once, oh, okay, here we go. Can we set up consultation with you?
Yes, you absolutely can. I would love that. I try not to take any new ones between like Thanksgiving and the New Year because it's just crazy this time of year, everybody trying to finish stuff up. But after the New Year, absolutely, I would love to. You can hop on our website or contact our office. The phone number goes right to the front desk. They can always find me. My legal assistant's name is Cassie. You can always ask for her. She's the goddess of my calendar and has access to all the things. And if you're a little more tech savvy, you can also schedule with me online. We have a link we can send you and you can just book yourself. So whatever works for you.
Okay. Okay, well, for the sake of the time, we want to thank everyone who joined us for today's Ranching 101 webinar, and we hope everyone has a great afternoon. And we look forward to seeing you all in the new year on January 21st for our first 2025 Ranching 101 webinar. It'll be over a 2025 guide to optimizing herd health. So thanks for joining us, and we look forward to seeing you in the new year.
Yeah, thank you all. Appreciate it.
Thanks. Have a good one.